SJC-11494, Commonwealth v. Edmund D. LaChance, Jr.
Yes, counsel, good morning.
Good morning, Your Honors. Albajato on behalf of Edmund LaChance. When the performance prong of the Safarian test has been found by the lower court, prejudice must be presumed in a public trial context.
I think the lower court didn't actually make a finding, just assumed that the attorney's conduct was below that would be required of an ordinary fallible lawyer. Is that right?
That's right. The trial court assumed, for the sake of the opinion, that the affidavits of all of the parties that had been submitted were credited and that the performance was measurably below, which distinguishes that particular issue from all the other cases where there wasn't a finding. Because
there's no finding, there's just an assumption here. So presumably it would have to be sent back for a real evidentiary hearing.
That's correct. This court did not determine that there was ever a situation where a finding itself was overturned by the trial court, unless it was clearly
if you prevail in this case, just to follow up, you prevail in this case, it's not that you get a new trial, it gets remanded, correct?
Correct. There could be a further evidentiary hearing to determine whether or not the court's assumption is true, whether or not those affidavits were credited. Correct.
So let me ask you this: you concede, as you should, that he waived, at least at trial, he waived his right to a public trial. Is that right?
No, I don't concede that he waived his right to a public trial, because trial counsel indicated, although he knew it was a common practice, he did not know if this particular courtroom was closed.
Okay. Well, he didn't object. He procedurally waived the issue. Correct?
Well,
are you saying no?
Well, if he procedurally waived the issue because this is the motion for new trial issue, then the substantial risk of miscarriage of justice standard would have the same result as the ineffective assistance of counsel. I think in Hardy, this court found that essentially the analysis would be the same in a public trial context, because it's a structural error, whether the court reviewed ineffective assistance of counsel or whether the court used substantial risk of miscarriage of justice, because the two prejudice prongs of substantial risk could not be met in a structural error case. So,
I'm sorry. Ineffective assistance, let me just understand this. Hasn't your client waived his claim of ineffective assistance of counsel as well as his claim of violation of his right to a public trial?
In terms of waiver, the procedural default, the claim, whether or not it was waived, even if it were the ineffective assistance of counsel claim.
Even if that's also waived, you're still saying that structural error is structural error, that's it, no matter what? No,
I'm saying that that defendant still has a right to have his claim reviewed by this court under the substantial risk.
But substantial risk, where's the substantial risk? That requires some showing of substantial risk.
Well, substantial risk of miscarriage of justice is akin to the plain error rule, say federally. And the Supreme Court has indicated that the plain error rule, that the right to a public trial under the Sixth Amendment isn't subject to the plain error rule because it's a structural error. So if our substantial risk is akin to the plain error, and substantial risk is the same, essentially, I believe the court said in Hardy, essentially the same analysis and essentially the same outcome, then prejudice must be presumed under the structural error.
In Bucci, didn't the First Circuit find no plain error?
I believe in Bucci, the court did not find a plain error in those circumstances, but in that case, as well as in Johnson, and this court, as well as in Horton, recognized that the substantial risk and the plain error are generally the same, because all four prongs of each test.
I guess all I'm getting to is, and maybe I'm misremembering Bucci, but you still need to deal, right, with the situation where if there has been a procedural waiver, when you're looking at substantial risk sort of after the fact, does it incorporate, do you use structural error or do you use substantial risk, which really looks at what is the harm to that particular defendant.
I believe you use substantial risk, but you don't need to prove harm.
All right, well,
That's
When
what
the
substantial
Supreme
risk
Court-
is. That's what substantial risk is.
Well, that's two prongs of substantial risk, and so if there's no other standard of review when a claim is procedurally defaulted, under the plain error test, the Supreme Court has indicated, those two prongs of the plain error don't have to be satisfied, because it's impossible.
The Supreme Court has never decided that after a procedural waiver of the right to a public trial, that there is presumed prejudice.
That's
never.
right. They have never reached it on procedural default. They have indicated that the plain error test is not applicable to structural errors. And if you accept that the right to a public trial is a structural error and it's not subject to the plain
Well,
error
they've
test,
decided it's limited to, it cannot be the standard in some categories of structural error.
in some categories of structural error, I can't think of a situation.
If structural error can be waived, how can you say the waiver of it is presumptively prejudicial?
Well, they can be waived by a knowing, willing, and voluntary waiver of a known right by either trial counsel or by the defendant at trial. And if he's procedurally defaulted, there is no other standard except substantial risk of miscarriage of justice. And if prejudice is presumed under ineffective assistance, then prejudice must be presumed under the substantial risk test, because there is no other way to show prejudice. If prejudice is impossible to be shown in a structural error, then it is impossible to show whether it's under ineffective assistance or a substantial risk test. Because if the prejudice is impossible to provide evidence of, as the Supreme Court has said, because it's so insidious into a trial, then it would be impossible under any of the tests given to show that that were possible.
Are you basically saying that review is then impossible?
I'm sorry, Your Honor?
Are you basically saying then that review is not really possible if you're required to show prejudice, and prejudice is impossible to show, then the point of review is itself thwarted?
Well, there are two other prongs to the substantial risk, and so that review would have to be subject to those two prongs, whether there is error, whether the error is plain on the record. And so, of course, there would always be review. But whether the claim was procedurally defaulted or whether the claim was still viable under some other standard of review, the substantial risk test would not require, as the ineffective assistance of counsel test would not require the proof of prejudice.
So your claim here, going back to the issue of whether counsel was ineffective, I gather that the courtroom was a standing room only at the time with jurors packed in. So is it your view that there was an entitlement that the relatives be allowed inside even then?
Yes, and even if they weren't, there would have to be, if there was going to be a closure, there would have had to have been an analysis under Waller.
So why is, so I mean, let's take it that certainly when the jurors left, they could have and should have been allowed in. Why is counsel ineffective for not pressing that right where his client has not told him that that's important to him?
Well, he doesn't know that the courtroom was closed in my particular instance. He can't recall whether or not it was closed, even though he does indicate that he recalled that it was common practice at the time in Middlesex County to close a courtroom. And he also goes on to say that even if he knew that it was closed, I believe that he would not have objected because he didn't know it was objectionable. And I think that's a little bit different from saying that he knew that it was objectionable and just didn't know if the courtroom was closed. He says he didn't know it was objectionable.
But his client never said it's important to me that my relatives be there, I gather. There's no evidence of that in the affidavit.
That's right. There's no evidence of that.
So, I mean, it seems to me that counsel right now is focused on choosing a proper jury. Why should counsel be focused, in terms of being effective, on having the relatives sit in the back of the courtroom while jurors at sidebar are being questioned? I mean, why is it ineffective for counsel to say, I need to insist upon the right of the relatives to be in the back of the courtroom where my client has not said it's important to him so that they cannot hear what's going on?
Of course, Your Honor. He needs to be focused on picking the jury. But in this particular case, he says, I didn't know if it was closed, so I wasn't paying attention, but that's okay. Even if I wasn't paying attention, I wouldn't have objected anyway because I didn't know it was objectionable, meaning I didn't know it was a law. So certainly, if the right to a public counsel, at least since Presley attaches at the time of jury impanelment, then he should have known that there was a right to a public counsel, and he should have known it was objectionable had it not occurred. Now, he does not know if it occurred in this particular case, and that's a separate question of whether or not that's ineffective. Here you have the lower court indicating that, presuming if his affidavit is credited, and presuming the other affidavits are credited, that there was ineffective assistance, at least in terms of performance, that Safarian had been met.
I'm sorry, I can't remember, but did he also say that if I did know it was objectionable, I would have objected?
I don't believe he goes on to say that second portion. I think the last line of his affidavit, and that was submitted with the second motion for reconsideration, was that had I known that it was closed, I would not have objected because I did not know what was objectionable. I think that's actually the last sentence. He does not say he would have objected had he known that it were closed.
Well, wasn't the circumstance in Morganti as well, which we just decided recently? The lawyer said he really wasn't aware that the right to a public trial extended to the voir dire?
Well, I think in Morganti and Alabord, the additional problem was that the lower court didn't recognize counsel's performance at all. And so when there wasn't recognition from the trial court regarding counsel's performance, that this could then say, when there isn't this finding, we can determine the facts, even though it's not within the appellate court's purview to do that. We can look at the facts and determine whether or not the performance prong has been met when there isn't this indication from the trial court that it occurred, and this court found that that was the culture at the time, in at least insofar as I believe Brockton was concerned, and perhaps even in some other counties, as in Middlesex.
So if this goes back, isn't that essentially there'll be a hearing on whether this was a recognized practice and whether the bar honored that practice, and isn't it going to end up to be the same result as Morganti?
I don't think it's going to end up to be the same result as Morganti, because the attorney did not know the law and did not know that this courtroom was closed, and then substantial risk would be analyzed in this particular case. And when the two prongs of prejudice of substantial risk cannot be met, as they could not in the plain error test, then prejudice would be presumed and he would obtain a new trial.
How do you read, it wasn't directly at issue because of the way the facts were, but you don't think that Lavoie suggests that, that it actually is, that in this kind of procedurally waived situation where you're into the realm of ineffective assistance of counsel, that the standard is, was there harm, that it's not presumptively harmful?
I do not read Lavoie to say that it is not presumptively harmful in this kind of situation under substantial risk, because of the akinness of substantial risk to the plain error test, where in certain structural errors under the plain error test, prejudice must be presumed. And so in Lavoie, Horton, Dyer, Hardy, Alabord, all of those cases, there was a finding by this court that there was some tactical reason why counsel could have or would have objected, whether it was for a more racially biased jury, the comfort of the jury, not having family members being intermingled, or more candid responses. But in this particular case, there is not, the court indicates that there appears to be no tactical reason why. And there's not a finding, but the court does state it appears to be that there was no tactical reason for the attorney not to object.
What about finality? What about finality here? You've got, it's not raised on direct appeal, okay. Neither the public trial right nor ineffective assistance. It's not raised in two motions, motions for new trial filed after the appeal is denied, and in the appeals of those denials. Where's finality come in here? Well, I mean, isn't that a legitimate concern that this thing can go on forever because it's not raised in a timely fashion? Certainly wasn't raised in a timely fashion at trial.
True. However, when it's a structural error, there has not been the opportunity.
Finality makes no difference, in other words. If there's a structural error, it's there forever.
When the structural error occurs, yes, it's there forever. It's a constitutional right that is so important that the Supreme Court said it's impossible.
But the Supreme Court has never said that in a procedurally waived situation, structural error means presumed prejudice.
Well, they haven't in terms of a right to a public trial, but they've indicated that structural errors are not subject to the plain error test. And so therefore—
Ever, no matter what the structural error is?
Well, the cases that the Supreme Court has indicated that a structural error, not the right to a public trial, but structural errors, if you accept that the right to a public trial is one, that prejudice must be presumed.
But what about the 11th Circuit, People versus Vaughn?
Well, People versus Vaughn, that's a Michigan case, Your Honor. It stands alone in terms of applying.
I'm sorry, People versus Vaughn. Go ahead. I'm sorry. Agrees with the People versus Vaughn is a Michigan case. Agrees with the 11th Circuit.
Correct. Yes, correct. And so far as the issue of whether or not prejudice is presumed in a procedurally defaulted case, Michigan stands alone. Minnesota, Arizona, Connecticut, Pennsylvania, Washington, Maryland, New York, California, a number of other states, a number of other circuits have all found that the right to a public trial or a structural error is preserved, and prejudice must be presumed after procedural default.
All of those states have decided that.
Correct.
Okay.
Council will have to leave it there.
Thank you,
very
Your
much.
Honors.
Good morning. My name is Michael Caneb. I'm an assistant district attorney from Middlesex on behalf of the Commonwealth. It's something of a surprise to be here today addressing this issue because this court has already decided the questions raised by this defendant's appeal. This court has said that there's a single standard that governs procedurally defaulted public trial claims. That is reviewed whether it's ineffective assistance claim or whether it's a waived claim. Both of those theories of waiver were reviewed in Horton and Dyer. And this court concluded in both those cases that under either form of waiver, the defendant must show particularized harm. And I would just direct the court, and I do in my brief, to Dyer footnote number 7 that addresses the defendant's argument head on and says that the miscarriage standard does not conflict with structural error because the miscarriage standard recognizes that it's dealing with a waived claim and that the alternative that the defendant is suggesting ignores what the court said in Cohen, that public trial rights may be waived, or what this court and the Supreme Court has said in a number of other structural error claims, some of which are, more concerning, I guess, fall into the category that the Supreme Court has said are, presumptively prejudicial, which the public trial claim does not fall into. The defendant is really asking the court to change the law that's already established by this court and to set up a special standard for a public trial claim when it's couched as ineffective assistance of counsel. Can it?
I think that I hear what you're saying. I think the difference, it's a factual difference, but Dyer, and I can't remember about Horton, but certainly Dyer, is a situation where, if I'm recalling correctly, it really was, it was a situation of coming into the lobby for the individual voir dire, as opposed to, which didn't raise the question of did counsel really know that this was a denial or it wasn't following the public trial right, as opposed to the Lavoie and the other cases where it really, there was a practice in many counties of actually closing the courtroom, and I think, as these cases have, Morganti and others have said, it was a practice that a lot of people went along with, whether they knew it was wrong or not. So it's sort of more focused in Dyer that it was actually giving up a right. At the time, they would know they were giving up a right.
Your Honor, I still think it's evaluated under an objective standard. Whether it was giving up a right or failing to protect a right, would it have made a difference? And in any event, both those decisions go to the second prong. They both go to the second Safarian prong, and they both say consistent. And there's been no backing off of this, although the court has appeared to hesitate. Lavoie, Albord, Morganti, they all depend upon the substantial risk measure. And when I also think it's the line of cases, Owens is obviously the one that's sort of the elephant in the room at the moment. That case, what it does is confuse a Strickland claim or a Safarian claim with a Waller claim. But if you're bringing an ineffective assistance of counsel claim, the public trial right as an absolute has dropped out. And when we review errors under ineffective assistance or under waived, the review is not done under the original standard. That's the cost of waiver. And so for counsel to be ineffective simply requires that counsel's mistake harmed the defense in some way, that the result would have been different but for counsel's error. So absent of showing of harm, the right of effective counsel is simply not implicated. And the defendant here made no showing of harm. In his first motion in this litigation, he admitted that he was unable to show any harm.
Is that not always going to be the case, though, with structural error?
With an open
pre-trial, things that are not having to do with the conduct of the trial themselves.
Right. Well, I think what a full understanding requires is to really think about what the Supreme Court has said about structural error. And structural error really falls into two categories, and this is discussed in the Gonzalez-Lopez case, which I cite in my brief, that structural error by itself does not mean inherently prejudicial, that there are really two kinds of errors that fall into that camp. One, and public trial is this category, the notion of harm is irrelevant. The origin of the term really began with Chapman trying to distinguish constitutional claims that could be evaluated under the harmless error standards and others that couldn't. And Chapman identified that there are certain errors that are so serious that we must presume prejudice. Those are a biased judge or jury, a complete denial of counsel, defective reasonable doubt instruction. In those situations, the error and the harm are actually coextensive. So there is always going to be a reasonable probability that things would have turned out differently if you didn't have a biased judge, if you weren't denied counsel. But there's a second category of structural error that works on an entirely different logic that doesn't have to do with essential fairness. These are structural only in the broadest sense because they have to do with the setup of the trial rather than the evidence that gets put in front of the jury. But in these cases, the Supreme Court doesn't presume prejudice. It relieves a defendant from showing prejudice because otherwise there'd simply be no way to enforce the right. And that's exactly what Waller says in footnote 9. The examples of these, there are three of them. There's the right to self-representation, which I think is an interesting one to look at. That's a structural error. You are never going to be able to show that you were prejudiced by the denial of your right to represent yourself, because the Supreme Court said in Wiggins that that's the exercise of a right that is almost always going to harm you if you get to exercise it. So if after a trial a defendant were to say, I wasn't aware that I was able to represent myself, and I'm not an attorney, it's kind of impossible to believe that he could ever demonstrate prejudice from that. And into that category, I would put public trial. I mean, the Supreme Court has put it in that category, and Waller itself puts it there.
In the category of what again?
In the category of structural errors where harm is an irrelevant concept.
Because public trials are just so intrinsic to the nature of what a trial is in our system. That they be open to the public.
Right. I mean, it's the harm is to an abstract concept, I think, if the public trial.
The harm is to a constitutional interest.
To a constitutional interest, but not to a defendant individually or to specific proceeding unless the defendant's able to show that. The language in Waller is that this is a right whose benefits are frequently intangible, difficult to prove, or a matter of chance. And then the court says, but the founders plainly thought it was important. So in Waller, and interestingly, Waller was decided in 1984, and the term structural error doesn't appear until 1986, and it's not really sort of organized as a concept until Fulminante in 1991. Waller.
But it basically does mean, back to the point, that if that is the kind of error you're asserting happened, that it's virtually silly to talk about trying to prove that that harmed you.
Well, I think given what Waller itself says about it, I think it's possible that it's a right whose violation could never identifiably by itself show up as a miscarriage of justice in the individual case.
So if you've waived it in some way and you're back into having to show prejudice, that's basically an exercise in futility.
Exactly. Just like the right of separate self-representation. If you're complaining that you lost your right of self-representation, or if you're complaining that the court that you were assigned a particular lawyer and you only found out later you could have chosen your lawyer.
Not all of the states who look at this look at it the way that you're suggesting we look at it, right? I mean, there are cases in which error is presumed. Harm is presumed.
I'm only aware of two states that do that. They're both named Washington. One is Washington, D.C., and there was a decision this past summer. And then there's state of Washington, which goes back to a 1923 decision. They have always assumed prejudice in that circumstance. But if I have a case...
About Montana.
I'm sorry, I'm not familiar with... this was a case that the defendant recently cited, I think?
Yeah. Just a moment. My point being that it's not entirely uniform, the analysis.
Well,
You could come, arguably, you could, you don't need to go as far as you're going. I mean, one could posit, perhaps, a case where a defendant had made it extremely clear to his lawyer that the most important thing to him is having his mother in the courtroom when jury is impaneling. And the lawyer says, we're not doing that because of X, Y, and Z. And if a court found that was manifestly unreasonable from the lawyer's perspective, arguably you could show harm to that defendant in that case.
yes, I think that's right.
And you don't have to go that far, though, you would say, because there was no evidence of Mr. LaChance saying to his lawyer, I really want my mother there.
No, Your Honor, there wasn't. And I also just want to point out another way in which while what I'm saying is very extreme, I think in practical reality it's not. That a public trial right protects the proper, this is what Waller says, it protects the proper observation of other rights and the proper performance in the courtroom. So it's hard to imagine that if a public trial violation was particularly troublesome, that it wouldn't have manifested itself as a violation of some other right. The judge wasn't paying attention, the jury was sleeping, the defendant's right of confrontation was uniformly disregarded. If the effect of a public trial denial is so pervasive, then it is going to show up in one of those other rights.
Not necessarily. Not necessarily. The problem could simply be that the proceeding, even though conducted pristinely otherwise, was done closed to the public.
Your Honor, that's correct. And at that point, you would say the defendant had not been harmed. And there's no concrete harm that he suffered. And you would have to be showing, in order to say he was harmed, that the result of the proceeding would have been different. And if I assume that the proceeding was pristine, then I can't assume that the result of the proceeding would have been different or that the defendant suffered some material harm.
And so therefore you're saying that there's just no way under the Strickland test that the ineffective assistance of counsel can be proved.
Well, I think Justice Botsford's example is the best one I've heard. I actually have sat around in a room with people trying to conceive of a way that you could have a major problem with a closed courtroom and it wouldn't manifest itself in some other right or some other error that would then provide grounds for a complaint. And the difference here really matters in the context of waiver and in the context of reversal. The costs of reversal are substantial. The waiver rule is set up to protect societies and the victim's interest in finality. It's set up to protect the Commonwealth from the prejudice of trying to retry a case like this, which is more than a decade old. And it's also set up to protect judicial economy. Now, the costs of reversal may be warranted where there's a miscarriage of justice to the individual defendant. That's essentially what we allow people to show when they bring a waived claim, that if the defendant was actually harmed, then it may be worth putting aside those costs. But I don't think that there's any decision that says that a reversal is warranted to vindicate an abstract principle when the defendant hasn't upfront made his request known.
But
if we were across the Fort Point Channel in federal court in the First Circuit, would the Owens case require a new trial here?
I think the Owens, well, we still have the first prong to be settled, which, as we pointed out when defense counsel was speaking, hasn't been settled. But I think that Owens has fallen into a logical trap. Where
What about Bucci? Am I wrong about Bucci?
No, you're correct about Bucci, Your Honor. But there was no ineffective assistance claim decided in Bucci. I think essentially the court said, well, it was a partial closure and there seems to have been some reason for it, so we're not stuck in Owens territory.
And is there a problem to have the Constitution interpreted differently depending on whether you're in state court or federal court in Boston or in
Well, the
Massachusetts?
United States Supreme Court and Owens itself has said that there isn't a problem with that Owens applies only to federal convictions because it's being decided under their rules, and that a state court decision would be due deference. And in fact, even Waller itself has two defendants in that case, one of whom preserved his claim by objecting and the other didn't. And this is discussed in footnote 2. And Waller goes on to say, state court rules may determine that this claim is waived, procedurally waived.
So in Owens, it was not based on the right to an open trial. It was not constitutional. It was rule based.
Oh, I'm sorry. It was constitutional, but this court isn't bound. My only point is that this court isn't bound by the Owens decision because it's an intermediate appeals court, and the Supreme Court has explicitly said we've never decided whether structural error will satisfy the third prong of the plain error test. That they've always deferred putting that. So there's no controlling Supreme Court precedent.
Thank you, counsel.
Thank you very much.